House is now in session.
We're here because Muslim women are not second-class citizens. We're here because Muslim women who choose to teach should not have to choose or be forced to choose between her conscience and her career.
Joe Ortega of Montreal's English School Board, one of the key voices in a case that could change Canada. This week, the Supreme Court held one of the longest hearings in its history about Quebec's secularism law, known as Bill 21. It prevents some civil servants from wearing religious symbols at work. For example, no hijabs, kippas, or turbans if you're a police officer or a teacher. The law is popular in Quebec, and the province's government says it's important for the separation of church and state. But this Supreme Court case has become about a lot more than that.
The backdrop of this case is religious symbols, but the true issue is the limit on legislative power on one hand and judicial power on the other.
Those are the words of David Grossman, a lawyer for one Muslim woman trying to fight the Quebec law. You see, in order to shield the secularism law from court challenges, Quebec's government preemptively used the notwithstanding clause, also known as Section 33 of the Charter of Rights and Freedoms. It allows a government to have a law even if it violates a charter right. But it's the subject of vigorous debate.
The notwithstanding clause is the last protection that we have in Quebec to make sure that our National Assembly has the right to protect our value of secularity of the state, separation between church and state. And
there must be limits on the use of the notwithstanding clause. If the clause can be used without meaningful constraint, courts could be rendered powerless, even when government sought to legalize.
In the past, it was rarely used, but that has changed. When Quebec used it preemptively, some other provinces thought that sounded like a good idea. Just a few examples. Saskatchewan used it to pass legislation around gender identity in schools. Alberta did the same, and Ontario used it to try to stop education workers from striking. The federal government is telling the Supreme Court it wants to see the notwithstanding clause limited, arguing it shouldn't be used to permanently suspend a right. It also says that even if the notwithstanding clause is used, courts should still weigh in on whether rights are being violated by that law. But some provinces say any new limits on the notwithstanding clause risk, quote, serious, irreparable, and unpredictable harm to the Canadian Federation. Those are the words of my next guest, Ontario's Attorney General, Doug Downey. Welcome to the House.
Thank you for having me.
So you did something pretty extraordinary this week. You personally argued this case before the Supreme Court. Why?
For a couple of reasons. One, to impress upon the court and to others that this really is a serious issue. And I've been managing thoughts about the notwithstanding clause for decades, quite frankly, and I felt very strongly about Ontario's position.
Okay, and this is a complex issue, so let's try to break this into a few parts. One of the things you argued against is having a court weigh in on whether a law violates the Charter if the notwithstanding clause has been used. Why is that a problem?
Well, the fact of the matter is the law doesn't violate the Charter if the notwithstanding clause is used. And that's how it was designed. When the framers put together the Charter, they very specifically reserved Section 33 for the legislatures to have the last word. And that is core to what our position was in front of the court.
Yeah, well, and so perhaps that was a poor choice of words on my part, but it's the violation of Charter rights. Like I take your point that the notwithstanding clause means it's not a violation of the Charter, but those essential rights that are otherwise protected by the Charter. Why shouldn't citizens know whether or not this law would violate them were the notwithstanding clause not used?
I give credit to the electorate. They are smart enough to understand what is being decided when the notwithstanding clause is invoked. It's really important that the electorate have the last word. And the 5-year sunset of the use of the notwithstanding clause, it's combined with the electoral cycle. which is at minimum or at maximum every 5 years. So it's tied to that, and they did that on purpose. They wanted the legislatures to be able to reflect the regional diversity that Canada has.
You say you give credit to the electorate. The Chief Justice, Richard Wagner, actually said in the course of these hearings, as he was asking some of the folks involved questions, couldn't this be used, a statement from a court, to inform the electorate? What's wrong with the electorate? If you give credit to them, what's wrong with them having a bit more information?
One of the things I said in my submissions to the Supreme Court is that we have to look at the practical implications of what that means. For us to have courts over a series of years give potentially different interpretations is not going to provide any sort of clarity for the electorate when they may have an election in between those conversations, from the Superior Court to the Court of Appeal up to leave for the Supreme Court and then ultimately potentially a hearing at the Supreme Court. That takes years to happen.
But courts do that all the time on a variety of other issues.
Absolutely, but there is no remedy to be given by the court because Section 33 was invoked and by definition makes the law valid.
Your government has used the notwithstanding clause twice, once in 2021 around third-party advertising ahead of elections, and the second time to impose a new contract on education workers to prevent a strike, although ultimately that law was repealed. I wonder, is there any discomfort around passing a law knowing it might violate charter rights were it not for the notwithstanding clause?
I think it's something that you, as a legislator, we have to turn our minds to when it's appropriate to use. But at the core of this argument in front of the Supreme Court is the right to use it. And Canada, and one of the beautiful things about Canada is that we have various jurisdictions. We have every province and territory. We have the ability to have our local important features defined and accentuated. The court system by design, by definition, is a unitary system. And as things move up to the Supreme Court, you get one answer that is then applicable across the country. And that's a tension that we have with our regional diversity.
To that point about the regional diversity, Quebec's Bill 21, which is, of course, in many ways at the heart of this, are you personally comfortable with that province using the notwithstanding clause to keep someone with, say, a hijab or a kippah from being a teacher?
There's two issues there. And so Bill 21 as an issue, we were very clear in our factum that Ontario would not pass that law. I
guess that's different than being comfortable with it, though, right? Does it make you uncomfortable that they're doing this?
This really isn't about how I feel, to be honest. The core issue here is the right for provinces to use the notwithstanding clause in the way that it was designed. And I am very comfortable in putting forward that the provinces have the right, the reserved right to use Section 33 to reflect the regional diversity that we have across Canada.
Yeah, and I guess I'm just trying to understand whether you, in any way, are given pause when you look at this specific example of how it's being used.
I believe very strongly in the federation. I believe very strongly in the provincial split with the federal government. We are a confederation by intention, and to have this unitary pull to uniformity across the country, I believe strongly that needs to be resisted.
One of the ideas that also came up during the hearings is that the notwithstanding clause could be, in essence, abused by what one lawyer described as a mini Trump in Canada. And the Chief Justice seemed interested in that as well. He asked a lawyer for the province of Quebec, this is a quote, "Let's say a tyrant, I won't name names, who has no respect for the separation of powers, who has no respect for equality between men and women, would suddenly pass, with the help of accomplices, legislation that would undermine the very foundation of our values." Does that scenario worry you?
I think the court was pretty clear that we're not in that position, and we're not. What the Chief Justice said, and has been reported by others, is that they're not going to make their decision based on extreme hypotheticals.
Okay, so the answer to the question, does that scenario worry you, is no.
It doesn't worry me.
The federal government has argued there should be some limits around the notwithstanding clause, that it shouldn't result in irreparable impairment of a charter right. What do you say to that?
There are constraints on the notwithstanding clause. It's only invoked for 5 years at a time. It's subject to the division of powers. It's subject to administrative actions by governments. There are a series of constraints on it. It also isn't retroactive. That was decided in Ford back in 1988. So there are a number of constraints. What some of the applicants are trying to put forward is that there should be more constraints, but it's not there in the text. It's not there in our constitutional history, and it shouldn't be, in our position, the result of this hearing.
In closing, I want to ask you about your invoking national unity in your address to the court. You said this is a generational test of our federation. What do you believe is at stake?
I think the very conversations that you're seeing happen about regional diversity, and you can pick any province, you will hear about their uniqueness, and you will hear about things that are important to them. And if we are into a different scenario where provinces are not allowed to govern with their uniqueness, I think we are going to be having a very, very difficult scenario.
Okay, I appreciate your time today.
Thank you so much.
Doug Downey is Attorney General of Ontario. In the next couple of weeks, the energy crisis is about to get worse. The last ships to sail through the Strait of Hormuz before the war with Iran began will soon reach their destinations, but nothing's coming behind them.
Even if you resume production today at full tilt, which you're not going to do, but even if you did, and even if Hormuz started flowing again today at full tilt, which it won't, but again, let's assume, you would still have this massive air pocket. That at this stage, we're looking at probably somewhere around 500 million barrels of what would normally be flowing out of Hormuz that has now not been flowing out of Hormuz.
As commodities expert Rory Johnston explains, there will be a gap that can't be solved, even if the war ended today. And that is the backdrop as Canadian officials and energy executives from all over met in Houston, Texas. Canada is pitching itself as a stable source of energy. But can this country really back up that talk? CBC's Kyle Bakx went to the conference and joined me earlier this week from Houston. Hey, Kyle, thanks for making time.
Hi there, Catherine.
So given all these challenges facing the global energy supply, I just want to start with the feeling amongst all these energy-minded folks in Houston right now. What are you hearing?
Well, it is a pretty unsettling mood here. The Middle East conflict is the absolute main focus here in Houston, the focal point of the global energy industry. It's impacting oil, natural gas, electricity markets, just about everything. And there are some countries around the world that are fearful of shortages and are even hoarding some fuels. So, for instance, South Korea and Thailand are restricting fuel exports. China is suspending some sales of fertilizer. Some countries are rationing jet fuel. And this is, it's just having a wide-ranging impact, not just on prices, but actual supplies. And industry leaders are not very optimistic about seeing movement of oil tankers and other ships through the Strait of Hormuz. For instance, the chief executive of Dow Chemicals took the stage here, laying out how he thinks it's going to take a long time for the energy industry to bounce back once this conflict is eventually over. He described it as requiring hundreds of days to recover.
Okay, so a lot of concern, a lot of anxiety, and in the midst of this, Canadian politicians are amongst those making their pitch. What are they saying?
Well, they're here promoting Canada and Canadian energy, and of course they are here looking for investment. As foreign countries look for a stable, reliable source of energy, they should look to Canada. And on stage here, Federal Natural Resources Minister Tim Hodgson proclaimed Canada is back. It's back promoting energy, wanting to grow the sector, and to get those projects to market. I interviewed Hodgson, and here's how he described what it means for Canada to be back.
We are no longer going to ask if, we are going to say how. We used to ask, if we would develop our natural resources, if we would develop our critical minerals. Today, we know that our allies desperately need our energy and they desperately need our critical minerals. It's a matter of national security. So the question isn't if, the question is how.
It's interesting, Kyle, because that Canada is back line, I mean, that's vintage Justin Trudeau. But here Hodgson is trying to distinguish himself from what's gone on in the past few years. How does the Canadian pitch feel different from what we've heard in the past?
Yeah, I've covered this event for many years, and previously the federal government was talking a lot more about its environmental performance when it comes to the energy sector, and there was less enthusiasm about growing the energy sector. Last year, so 12 months ago, I remember asking Alberta Premier Danielle Smith about Mark Carney because he had just won the Liberal leadership, and Smith didn't hold back, making disparaging remarks about Carney, saying he had been on a warpath against the energy industry his whole career. Well, what a difference a year can make. This week, Smith and Hodgson are basically arm in arm. I'm not kidding. They attend each other's events. They compliment each other on stage. Here's Smith about that complete reversal in the relationship.
I think the fact that you've got both Canada and Alberta here, as well as two other oil and gas producing provinces, I think that speaks a lot to how things have changed in the last year and a half.
And Catherine, even on Wednesday, here's another example. Alberta's energy minister, Brian Jean, he was on stage, and unprovoked, he starts heaping praise on the federal government. And it even caught the moderator, off guard. She was taken aback, saying she hasn't heard an Alberta energy minister compliment the federal government in several years.
Are you sure you're from Alberta, sir? But, a lot of positive talk. Smith, though, also said that Canada and Alberta are about to miss an early deadline in the MOU, the Memorandum of Understanding, this agreement that is possibly going to get Alberta a new pipeline. Certainly that's what Danielle Smith would like, that deadline coming up next week. Do you think the unity message is going to last if they're not getting things done in a timely fashion?
For now, I do. And speaking with people involved, it sounds like the province and federal government are about 95% aligned on these energy and environmental policies. There are a few outstanding issues, though. One is an agreement on hiking the industrial carbon tax. Another is working with oil sands companies on a deal on how to move ahead with developing the big Pathways carbon capture project. So those are supposed to be settled by April 1st, but Smith says that's not going to happen. More talks are needed. And it seems like the deal on that carbon capture project, that is the one that's probably going to take the most time to negotiate. And, from my discussions with people involved, I think one thing to watch is whether that proposed carbon capture facility, it could be reduced in size from what has been talked about in years previous, but it's going to still have to be big enough to actually put a dent in emissions.
Okay, so Alberta and the federal government feeling better than ever, I guess, or certainly better than recently in terms of their relationship. But another piece of this is energy executives. How confident are they feeling in what they're hearing from Canada?
They appreciate and notice the enthusiasm and the excitement. They talk about how they notice the change in tone, but it is skeptical optimism, though. A lot of companies want to see action, and they want to see proof. Here is former oil patch drilling company executive Kevin Crosser.
It's amazing the number of times people ask me that they think Canada's hoarding its own oil because the world is screaming for it. I'm like, no, we're not hoarding it. But we do need to figure out a way to prove to the rest of the world that if we are a stable energy superpower, it's time to deliver.
And Catherine, they want 2026 to be a year of action, seeing projects approved and seeing shovels in the ground.
You mentioned at the beginning of our conversation, Kyle, that Canada used to be talking a lot more about the environment. Given the pressure we're seeing from the war on Iran, is there still a conversation about environmental concerns around pipelines, sustainability, or is that sort of fallen away right now?
It's not a major focus, which I think reflects what's happening in the world. Climate change is a concern around the globe, but over the last 5 years, it has become less of a priority. The average person generally is more concerned about inflation and the cost of living. The Russia invasion of Ukraine caused an energy crisis, and people put their attention on energy security and grappling with these skyrocketing utility prices. And we're seeing that again now with the situation in the Middle East. Still, some industry executives here say climate is a priority and that their companies continue to focus on cutting emissions. And the reason is because they want to future-proof their projects. Some of these big companies are spending billions of dollars or tens of billions of dollars on new facilities to produce energy. And they want to make sure that they're producing low carbon sources of energy because they have customers around the world that care about reducing emissions, and they're going to be continuing to care about environmental performance for decades to come.
Lots to think about here. Thank you so much, Kyle.
Thank you.
The CBC's Kyle Bakx. Okay, that is it for us this week. Our crew on the house is Kristen Everson, Benjamin Lopez-Stephen, and Theo Van Bussicum. Our senior producer is Jennifer Chevalier. Technical production by Miguel Plant. I am Catherine Cullen. Thank you so much for listening.